Question 1. Regulatory review indicates that a foreign investment firm is considering a significant infrastructure development project in Vietnam, which is known to traverse areas with high biodiversity value. The firm's legal team needs to advise on the most prudent course of action to ensure full compliance with Vietnam's biodiversity conservation laws and any relevant ASEAN frameworks. Which of the following approaches best navigates this complex regulatory environment? Option A. Prioritize securing the necessary land use rights and initial project approvals quickly, deferring detailed biodiversity impact assessments until after construction has commenced. Option B. Conduct thorough legal due diligence, engaging local environmental law experts to identify all specific biodiversity conservation requirements under Vietnamese law and relevant ASEAN agreements, and develop a comprehensive mitigation and management plan for protected species and habitats. Option C. Focus on obtaining all standard environmental permits and licenses required for infrastructure projects, assuming that these will implicitly cover biodiversity considerations. Option D. Rely on the investment firm's existing internal environmental policies, which are designed for a different regulatory jurisdiction, and assume they are sufficient for compliance in Vietnam. The correct answer is B. Conduct thorough legal due diligence, engaging local environmental law experts to identify all specific biodiversity conservation requirements under Vietnamese law and relevant ASEAN agreements, and develop a comprehensive mitigation and management plan for protected species and habitats. Explanation. This scenario presents a professional challenge due to the complex interplay between economic development and environmental protection within the ASEAN region, specifically concerning biodiversity conservation laws in a member state like Vietnam. The need to balance potential foreign investment with the stringent requirements of national and regional biodiversity regulations demands careful judgment and a thorough understanding of legal obligations. The best professional approach involves a proactive and comprehensive legal due diligence process that prioritizes compliance with Vietnam's law on environmental protection and relevant ASEAN agreements on biodiversity. This approach requires engaging with local legal counsel specializing in environmental law to identify all applicable regulations, assess potential impacts on protected species and habitats, and develop mitigation strategies that align with both national legislation and international commitments. This ensures that the proposed development project not only avoids legal penalties, but also contributes to sustainable development goals, thereby safeguarding the company's reputation and long-term operational viability. An approach that focuses solely on obtaining the necessary permits without a deep dive into the underlying biodiversity conservation mandates is professionally unacceptable. This failure to conduct thorough due diligence risks overlooking critical environmental impact assessments or failing to implement adequate conservation measures, leading to potential violations of Vietnam's law on environmental protection and its obligations under agreements like the ASEAN Center for Biodiversity Act framework. Such an oversight could result in significant fines, project delays, or even outright cancellation, alongside reputational damage. Another professionally unacceptable approach is to assume that general environmental permits are sufficient without specific consideration for biodiversity. This overlooks the specialized nature of biodiversity conservation laws, which often require distinct assessments and management plans for protected areas, endangered species, and critical habitats. Relying on generic environmental compliance can lead to unintended harm to sensitive ecosystems, contravening the spirit and letter of Vietnam's biodiversity protection efforts and regional commitments. Finally, an approach that prioritizes speed of investment over environmental scrutiny is fundamentally flawed. While efficiency is important, it cannot come at the expense of legal and ethical obligations. This disregard for biodiversity conservation laws can lead to irreversible environmental damage, legal repercussions, and a breakdown of trust with regulatory bodies and local communities, ultimately jeopardizing the investment itself. Professionals should adopt a decision-making framework that begins with a comprehensive understanding of the regulatory landscape, including specific national laws and regional commitments. This should be followed by a risk assessment that identifies potential environmental impacts, particularly concerning biodiversity. Subsequently, Mitigation and management plans should be developed in consultation with legal and environmental experts, ensuring alignment with all applicable laws and best practices. Continuous monitoring and adaptation are crucial to maintain compliance and responsible environmental stewardship. Question 2. Performance analysis shows that a financial advisory firm in Alabama is assisting clients with significant investments in several ASEAN member states. A client has inquired about the direct impact of the ASEAN Intergovernmental Commission on Human Rights (ACER) on corporate accountability for human rights practices within these countries. Which of the following approaches best addresses the client's inquiry while adhering to professional ethical standards and accurately reflecting the ACER role? Option A. Advise the client that the ACER has the authority to investigate and impose penalties on companies operating in ASEAN member states that are found to be in violation of human rights standards. Option B. State that any recommendations or declarations made by the ACER are immediately legally binding on all companies operating within ASEAN member states, including those based in Alabama. Option C. Inform the client that the ACER is an irrelevant body for investment decisions, as it lacks any binding legal authority over corporate behavior in ASEAN countries. Option D. Explain that the ACER serves as a consultative body that promotes human rights through dialogue and the development of ASEAN human rights instruments, and while it does not have direct enforcement powers over corporations, its work can influence regional human rights standards and national policies. The correct answer is D. Explain that the ACER serves as a consultative body that promotes human rights through dialogue and the development of ASEAN human rights instruments, and while it does not have direct enforcement powers over corporations, its work can influence regional human rights standards and national policies. Explanation. Scenario analysis. This scenario is professionally challenging because it involves navigating the delicate balance between national sovereignty and regional cooperation on human rights issues within the ASEAN framework. A financial advisor operating in Alabama, who is also advising clients with investments in ASEAN member states, must understand the limitations and mandates of the ASEAN Intergovernmental Commission on Human Rights (ACER). When considering the ethical implications of their clients' investments, the advisor needs to avoid making unsubstantiated claims about ACER direct enforcement powers, while still acknowledging its role in promoting human rights standards. Correct approach analysis. The best professional practice involves accurately representing the ACER function as a consultative and promotional body, emphasizing its role in developing ASEAN human rights instruments and facilitating dialogue, rather than portraying it as a direct enforcement mechanism with judicial authority over corporate actions in member states. This approach is correct because it aligns with the ACER established mandate as outlined in its terms of reference, which focuses on promoting and protecting human rights through cooperation and dialogue among member states. It avoids misrepresenting the ACER capabilities and ensures that clients receive accurate information regarding the human rights landscape in ASEAN, thereby upholding professional integrity and avoiding potential legal or reputational risks associated with misleading advice. Incorrect approaches analysis. One incorrect approach involves asserting that the ACER can directly investigate and penalize companies operating in ASEAN member states for human rights violations. This is ethically and professionally unacceptable because it misrepresents the ACER mandate. The ACER does not possess judicial or enforcement powers to impose sanctions on private entities. Its role is primarily advisory and promotional, focusing on intergovernmental cooperation. Another incorrect approach is to dismiss the ACER entirely as irrelevant to investment decisions, arguing that it has no binding authority. While the ACER may not have direct enforcement powers, its work in developing human rights standards and promoting dialogue can influence national policies and corporate practices within ASEAN. Ignoring its existence and potential influence would be a failure to provide comprehensive advice on the evolving human rights landscape relevant to investments in the region. A further incorrect approach is to suggest that the ACER recommendations automatically translate into legally binding obligations for businesses in Alabama or ASEAN member states. The ACER recommendations are typically directed towards member states and aim to encourage the adoption of human rights principles. They do not create direct legal obligations for private companies without corresponding national legislation or international treaty ratification that incorporates such principles. Professional reasoning. Professionals in this situation should adopt a framework that prioritizes accuracy, transparency, and a comprehensive understanding of relevant regulatory bodies. This involves 1. Thoroughly researching the mandate and operational scope of the ACER and other relevant regional human rights mechanisms. 2. Clearly communicating the limitations and capabilities of these bodies to clients, avoiding hyperbole or misrepresentation. 3. Integrating an understanding of human rights considerations into investment analysis, recognizing that while direct enforcement may be limited, reputational and operational risks can still arise from human rights concerns. 4. Staying abreast of developments in regional human rights law and policy that could impact investments. Question 3. The control framework reveals that a family in rural Alabama is seeking to divide the estate of their deceased patriarch, who passed away without a will. The family elders present a claim that according to their long-standing community customs, the eldest son is entitled to a larger portion of the ancestral farmland than his siblings, a practice that predates Alabama's formal probate laws. How should legal counsel advise the family and the probate court regarding the distribution of the estate, considering the interplay between customary practices and Alabama's statutory inheritance laws? Option A. Advise the probate court to disregard the family's customary law entirely, as it is not codified within the Alabama Code and therefore has no legal standing in inheritance matters. Option B. Advise that while customary law may offer historical context, the distribution must strictly adhere to Alabama's intestate succession statutes, as these are the legally binding framework for property division in the state. Option C. Recommend that the customary law be applied directly to the estate distribution, as it represents the deeply held traditions of the family and their community. Option D. Suggest creating a unique distribution plan that attempts to merge elements of both the customary law and Alabama's intestate succession statutes to satisfy all parties. The correct answer is B. Advise that while customary law may offer historical context, the distribution must strictly adhere to Alabama's intestate succession statutes, as these are the legally binding framework for property division in the state. Explanation. The control framework reveals a complex situation involving the application of customary law within the modern legal system of Alabama, specifically concerning land inheritance. This scenario is professionally challenging because it requires navigating the intersection of established statutory law and deeply ingrained, often unwritten, customary practices. Professionals must exercise careful judgment to ensure legal compliance while respecting cultural norms and avoiding discriminatory outcomes. The potential for conflict between these two legal sources necessitates a nuanced approach that prioritizes fairness and adherence to Alabama's legal principles. The best professional approach involves recognizing the potential validity of customary law as a defense or mitigating factor, but only to the extent that it does not contravene Alabama's statutory inheritance laws or public policy. This means investigating the specific customary practice alleged by the family, understanding its historical context and application within their community, and then assessing whether it can be reconciled with the Alabama Code concerning intestate succession. If the customary practice aligns with or does not directly conflict with statutory requirements, and does not lead to an unjust or discriminatory outcome, it may be considered. This approach is correct because it acknowledges the potential influence of customary law as recognized in some legal traditions, while firmly grounding the ultimate decision in the established statutory framework of Alabama. It prioritizes legal accuracy and fairness, ensuring that any deviation from statutory norms is carefully scrutinized and justified. An incorrect approach would be to automatically uphold the customary law simply because it is a long-standing tradition within the family or community. This fails to acknowledge that Alabama law, like all U.S. states, operates under a codified statutory system for inheritance. Customary law, while influential in some contexts, does not supersede state statutes unless explicitly incorporated or recognized by them. This approach risks violating the Alabama Code regarding intestate succession, potentially leading to an illegal distribution of property and legal challenges. Another incorrect approach would be to dismiss the customary law entirely without any investigation, rigidly adhering only to the letter of the Alabama Code. While the statutory law is paramount, a complete disregard for the family's customary practices could lead to an outcome that, while legally compliant on its face, is perceived as deeply unfair and culturally insensitive by the community involved. This could erode trust and create further disputes, even if the initial legal distribution is technically correct. It fails to consider the broader implications of legal decisions within a community context. A further incorrect approach would be to attempt to blend the customary law and statutory law in a way that creates an entirely new hybrid inheritance rule. This is problematic as it lacks legal basis and could lead to an unpredictable and unenforceable outcome. Professionals must apply existing legal frameworks, not create new ones based on conflicting traditions. The professional reasoning process for similar situations should involve: first, a thorough understanding of the relevant Alabama statutory law governing inheritance. Second, a careful and respectful investigation into the specific customary law being invoked, seeking to understand its nature, scope, and historical application. Third, a critical analysis of how the customary law interacts with the statutory law, identifying any points of conflict or compatibility. Fourth, an assessment of whether upholding or considering the customary law would result in an outcome that is equitable, non-discriminatory, and consistent with Alabama's public policy. Finally, a decision that is legally sound, ethically defensible, and sensitive to the cultural context of the parties involved. Question 4. The evaluation methodology shows that a financial services firm is planning to expand its digital lending operations across several ASEAN member states, including Thailand, Indonesia, and the Philippines. The firm has developed a standardized set of terms and conditions for its loan agreements, based on a general understanding of ASEAN principles for consumer protection. What is the most prudent course of action for the firm to ensure compliance with regional variations in legal practices? Option A. Defer the full implementation of the digital lending operations until a more unified and harmonized legal framework for digital lending is established across all target ASEAN member states. Option B. Adopt the legal and regulatory framework of Singapore, a leading ASEAN economy, as the benchmark for all operations, assuming other member states will eventually align with its standards. Option C. Conduct detailed legal and regulatory reviews in Thailand, Indonesia, and the Philippines to identify and adapt the standardized terms and conditions to each country's specific data privacy, consumer credit, and dispute resolution laws. Option D. Rely on the general ASEAN principles for consumer protection as a sufficient baseline, assuming that national implementations will be broadly similar across these member states. The correct answer is C. Conduct detailed legal and regulatory reviews in Thailand, Indonesia, and the Philippines to identify and adapt the standardized terms and conditions to each country's specific data privacy, consumer credit, and dispute resolution laws. Explanation. The evaluation methodology shows that understanding regional variations in legal practices within ASEAN is crucial for effective cross-border transactions and compliance. This scenario is professionally challenging because it requires navigating potentially conflicting legal interpretations and enforcement mechanisms across different ASEAN member states, even when a general ASEAN framework might exist. The lack of complete harmonization means that what is standard practice in one country could be a regulatory breach in another. Careful judgment is required to identify and mitigate these differences. The best approach involves proactively identifying and documenting the specific legal and regulatory nuances of each relevant ASEAN jurisdiction. This means conducting thorough due diligence that goes beyond general ASEAN principles to examine the domestic laws and regulatory interpretations of countries like Singapore, Malaysia, and Vietnam concerning data privacy and consumer protection. This approach is correct because it directly addresses the core challenge of regional variations by seeking specific, actionable knowledge. Adherence to the specific domestic laws of each ASEAN member state is paramount, as ASEAN frameworks often serve as aspirational goals or minimum standards, with individual member states retaining significant autonomy in their regulatory implementation and enforcement. This aligns with the principle of respecting national sovereignty and the practical reality of diverse legal systems. An approach that relies solely on general ASEAN guidelines without verifying specific national implementations is professionally unacceptable. This fails to acknowledge that ASEAN directives are often non-binding or require national legislation for full effect, leading to potential non-compliance with specific member state laws. Similarly, assuming that legal practices in one developed ASEAN economy, such as Singapore, will be identical in less developed economies like Cambodia is a significant oversight. This ignores the vast disparities in legal infrastructure, enforcement capacity, and regulatory maturity across the region, risking regulatory breaches and reputational damage. Finally, adopting a wait-and-see approach, hoping that any discrepancies will be resolved through future harmonization efforts, is also professionally unsound. This passive stance exposes the business to immediate legal and financial risks, as regulatory bodies in individual member states will enforce their existing laws regardless of ongoing harmonization discussions. Professionals should employ a decision-making framework that prioritizes proactive research, granular analysis of specific national laws, and consultation with local legal experts in each relevant ASEAN jurisdiction. This framework should involve a risk-based assessment, identifying areas where regional variations are most likely to impact operations and compliance, and developing tailored strategies for each market. Question 5. The monitoring system demonstrates that a financial institution in Alabama is reviewing a complex cross-border transaction involving a client whose primary business operations and contractual agreements are governed by the legal principles of a civil law jurisdiction. When assessing the enforceability of certain clauses within the transaction documents, which approach best aligns with Alabama's legal framework and professional obligations? Option A. Treat the interpretation of all contractual clauses as solely a matter of statutory construction, without giving significant weight to judicial precedent developed in Alabama courts. Option B. Prioritize the interpretation of contractual clauses based on established Alabama case law and statutory provisions, while considering the civil law background of the client for practical understanding of their expectations. Option C. Assume that the civil law principles governing the client's primary operations are directly applicable to the interpretation of the transaction documents, given the client's familiarity with that system. Option D. Apply the codified statutes of the client's civil law jurisdiction directly to the transaction documents, disregarding any potential influence of Alabama's common law tradition. The correct answer is B. Prioritize the interpretation of contractual clauses based on established Alabama case law and statutory provisions, while considering the civil law background of the client for practical understanding of their expectations. Explanation. The monitoring system demonstrates a potential conflict arising from differing legal traditions within Alabama's financial services sector. This scenario is professionally challenging because financial institutions operating in Alabama may encounter clients or transactions originating from jurisdictions with distinct legal frameworks, necessitating a nuanced understanding of how these traditions impact contractual obligations, dispute resolution, and regulatory compliance. Careful judgment is required to ensure adherence to Alabama's specific legal landscape, while acknowledging the practical implications of dealing with parties accustomed to different legal systems. The best professional approach involves recognizing that Alabama operates under a common law tradition. This means that legal precedent, established through judicial decisions, plays a significant role in interpreting statutes and governing commercial relationships. When assessing a client's contractual obligations or potential liabilities, professionals must prioritize understanding how Alabama courts would interpret the agreement based on existing case law and statutory provisions. This approach ensures compliance with the governing law of Alabama and provides a predictable framework for legal analysis and dispute resolution within the state. An incorrect approach would be to assume that the principles of civil law, which rely heavily on codified statutes and less on judicial precedent, are directly applicable or can be used interchangeably with common law principles in Alabama. This failure to distinguish between the two traditions could lead to misinterpretations of contractual intent, incorrect assessments of legal rights and obligations, and ultimately, non-compliance with Alabama's legal requirements. For instance, relying solely on a civil law interpretation of a contract's good faith provisions might overlook specific common law nuances developed through Alabama case law, creating legal exposure. Another incorrect approach is to apply the legal framework of a foreign civil law jurisdiction without first determining its relevance and applicability under Alabama's choice of law rules. While understanding foreign legal systems is valuable, directly imposing their interpretations onto an Alabama-based transaction or dispute is legally unsound. This overlooks the fundamental principle that Alabama law governs matters within its territorial jurisdiction, unless specific exceptions apply, and even then, The analysis would be conducted through the lens of Alabama's conflict of laws principles. A third incorrect approach is to treat all contractual disputes as purely matters of statutory interpretation, neglecting the significant role of judicial precedent in Alabama's common law system. While statutes are foundational, their application and meaning are often clarified and refined by court decisions. Ignoring this body of case law can lead to an incomplete or inaccurate understanding of legal obligations and rights, potentially resulting in flawed advice or action. The professional reasoning process for similar situations should begin with identifying the governing jurisdiction, which in this case is Alabama. Subsequently, the professional must determine whether the legal tradition of that jurisdiction is common law or civil law. For Alabama, this means recognizing its common law heritage. The next step is to analyze the specific issue, e.g., contractual interpretation, regulatory compliance, through the established framework of Alabama's common law, consulting relevant statutes and, crucially, relevant Alabama case law. If parties from civil law jurisdictions are involved, their legal traditions should be understood for practical purposes and to anticipate potential differences in interpretation. But the ultimate legal analysis and advice must be grounded in Alabama's common law principles. Question 6. Market research demonstrates a significant opportunity for a new industrial park development in a coastal region of Malaysia, which is expected to boost local employment and economic growth. However, preliminary environmental assessments indicate potential impacts on marine ecosystems. Considering the objectives of the ASEAN socio-cultural community, ask, Blueprint, what is the most prudent risk assessment approach for the project developers to adopt? Option A. Undertake a limited stakeholder consultation process with local government officials only, focusing on regulatory compliance rather than deep engagement with the broader community's cultural values. Option B. Focus primarily on the environmental impact assessment and economic projections, assuming that any socio-cultural concerns can be addressed through general corporate social responsibility initiatives after the park is operational. Option C. Prioritize securing investment and fast-tracking the development process, with a commitment to address any socio-cultural issues that may arise as secondary concerns once the economic benefits are realized. Option D. Conduct a comprehensive socio-cultural impact assessment that includes in-depth consultations with local communities, indigenous groups, and cultural heritage experts to identify and mitigate potential negative effects on traditional practices, cultural sites, and community cohesion, alongside the environmental assessment. The correct answer is D. Conduct a comprehensive socio-cultural impact assessment that includes in-depth consultations with local communities, indigenous groups, and cultural heritage experts to identify and mitigate potential negative effects on traditional practices, cultural sites, and community cohesion, alongside the environmental assessment. Explanation. This scenario is professionally challenging because it requires balancing the economic imperative of a new development with the potential for significant negative impacts on the socio-cultural fabric of a community within an ASEAN member state. The pressure to proceed quickly with investment can lead to overlooking or downplaying the ask objectives, particularly those related to cultural heritage preservation and community well-being. Careful judgment is required to ensure that economic progress does not come at the expense of the region's shared values and the rights of its people. The best professional approach involves proactively identifying and assessing potential socio-cultural risks associated with the proposed industrial park development. This entails conducting thorough stakeholder consultations with local communities, cultural heritage experts, and relevant government agencies within the specific ASEAN member state. The goal is to understand the potential impacts on cultural practices, traditions, historical sites, and community cohesion, and to develop mitigation strategies that align with the Ask Blueprint's emphasis on cultural preservation and people-centered development. This approach is correct because it directly addresses the Ask core principles of promoting a sustainable and inclusive socio-cultural community by prioritizing the identification and management of risks to cultural heritage and community well-being before significant investment is committed. It demonstrates a commitment to responsible development that respects the unique cultural identity of the region. An incorrect approach would be to proceed with the development based solely on economic projections and environmental impact assessments, without a dedicated focus on socio-cultural implications. This fails to acknowledge the ASK mandate to foster a shared sense of ASEAN identity and promote cultural understanding and cooperation. Another incorrect approach would be to conduct superficial consultations that do not genuinely engage with local communities or their cultural concerns, thereby creating a false sense of compliance. This approach undermines the ASK commitment to people-centered development and risks alienating communities, leading to social unrest and reputational damage. Finally, an approach that prioritizes immediate economic gains over long-term socio-cultural sustainability, by assuming that any negative impacts can be addressed after the project is underway, is also professionally unacceptable. This demonstrates a disregard for the ASK vision of a resilient and harmonious community and ignores the potential for irreversible cultural loss. Professionals should adopt a decision-making framework that integrates socio-cultural risk assessment as a fundamental component of any development project within an ASEAN context. This involves 1. Understanding the specific ASK objectives relevant to the project's location and nature. 2. Conducting comprehensive socio-cultural impact assessments that go beyond mere environmental considerations. 3. Engaging in meaningful and inclusive stakeholder dialogue. 4. Developing and implementing robust mitigation and enhancement plans that are culturally sensitive and community-driven. 5. Continuously monitoring and evaluating the socio-cultural impacts throughout the project lifecycle. Question 7. Operational review demonstrates that Alabama, as an ASEAN member state, is facing challenges in fully integrating the objectives of the ASEAN Political Security Community (APSC) Blueprint 2025 into its national governance framework. Which of the following approaches represents the most effective and compliant strategy for Alabama to enhance its implementation of the APSC? Option A. Undertake a comprehensive review of Alabama's existing laws and policies to identify areas of divergence from APSC commitments, develop a legislative roadmap for necessary amendments, and establish a dedicated interagency task force to oversee coordinated implementation and reporting. Option B. Delegate the primary responsibility for APSC implementation to the Ministry of Foreign Affairs, with minimal consultation with other domestic ministries or regional bodies. Option C. Issue a public statement reaffirming Alabama's commitment to the APSC and initiate a series of public awareness campaigns to inform citizens about the APSC general goals. Option D. Focus implementation efforts exclusively on APSC initiatives that offer immediate economic benefits to Alabama, while deferring commitments that require significant legislative changes or resource allocation. The correct answer is A. Undertake a comprehensive review of Alabama's existing laws and policies to identify areas of divergence from APSC commitments, develop a legislative roadmap for necessary amendments, and establish a dedicated interagency task force to oversee coordinated implementation and reporting. Explanation. The scenario presents a professional challenge in navigating the complexities of implementing the ASEAN Political Security Community (APSC) Blueprint 2025 within a specific member state, Alabama, which is a fictional construct for this exam's purpose. The challenge lies in balancing national sovereignty and domestic legal frameworks with regional commitments and the overarching goals of the APSC. Careful judgment is required to ensure that implementation strategies are both effective in achieving APSC objectives and compliant with Alabama's existing legal and administrative structures. The best approach involves a comprehensive and integrated strategy that prioritizes the alignment of national policies and legal instruments with the APSC objectives. This includes conducting thorough legal and policy reviews to identify gaps, developing a clear roadmap for legislative amendments or new enactments, and establishing robust interagency coordination mechanisms within Alabama. Furthermore, it necessitates proactive engagement with ASEAN bodies and other member states to share best practices and address potential implementation hurdles. This approach is correct because it directly addresses the core requirement of the APSC, which is to foster a peaceful, stable, and dynamic region through collective action and adherence to agreed-upon principles and commitments. It ensures that implementation is not merely a superficial exercise, but a substantive integration of APSC goals into the fabric of Alabama's governance, supported by the necessary legal and administrative infrastructure. An incorrect approach would be to focus solely on symbolic gestures or superficial policy statements without undertaking the necessary legal and institutional reforms. This fails to create tangible progress towards the app's goals and neglects the foundational requirement for effective regional integration. Such an approach risks undermining the credibility of Alabama's commitment to the apps and could lead to a disconnect between regional aspirations and national realities. Another incorrect approach would be to prioritize domestic political considerations or short-term economic gains over the long-term strategic objectives of the apps. This could lead to selective implementation of apps commitments, where only aspects that are politically expedient or economically beneficial are adopted, while more challenging but crucial elements are ignored. This selective approach is ethically problematic as it violates the spirit of solidarity and mutual commitment inherent in ASEAN. A further incorrect approach would be to delegate the entire implementation process to a single, under-resourced government department, without adequate cross-ministerial consultation or public engagement. This siloed approach is likely to result in fragmented efforts, missed opportunities for synergy, and a lack of buy-in from relevant stakeholders. It also fails to acknowledge the multifaceted nature of the apps, which requires a coordinated effort across various sectors of governance. Professionals should employ a decision-making framework that begins with a clear understanding of the app's objectives and the specific commitments made by member states. This should be followed by a thorough assessment of the existing national legal and policy landscape to identify areas requiring adaptation. A consultative process involving all relevant government agencies, civil society, and the private sector is crucial for developing a comprehensive and sustainable implementation plan. Finally, continuous monitoring and evaluation mechanisms should be established to track progress and make necessary adjustments, ensuring that the implementation remains aligned with both apps' goals and national interests. Question 8. Operational review demonstrates that a financial institution in Malaysia is developing a new investment product intended for a broad customer base, including those seeking Sharia-compliant options. The institution's internal legal team has provided an opinion on the product's adherence to Islamic law, but there is concern about potential discrepancies with established Sharia interpretations prevalent in Malaysia. What is the most prudent and compliant approach for the institution to ensure the product's Sharia compliance and regulatory adherence? Option A. Engage recognized Malaysian Sharia scholars and relevant regulatory bodies for comprehensive review and approval throughout the product development process. Option B. Defer seeking formal Sharia certification until a customer complaint necessitates it to minimize upfront administrative burden. Option C. Rely solely on the internal legal team's interpretation of Sharia principles, assuming their expertise is sufficient for Malaysian context. Option D. Adopt Sharia compliance frameworks and certifications from other ASEAN countries without specific validation for the Malaysian market. The correct answer is A. Engage recognized Malaysian Sharia scholars and relevant regulatory bodies for comprehensive review and approval throughout the product development process. Explanation. This scenario presents a professional challenge due to the inherent complexities of navigating diverse Islamic legal interpretations within a single ASEAN jurisdiction, specifically Malaysia, which has a dual legal system. The challenge lies in ensuring compliance with both civil law and Sharia law, particularly when financial products are designed to appeal to a broad customer base that may include individuals with varying degrees of adherence to Islamic principles. Careful judgment is required to balance commercial objectives with the ethical and regulatory imperative to offer Sharia-compliant financial instruments that are genuinely aligned with Islamic jurisprudence. The best approach involves a comprehensive and proactive engagement with recognized Sharia scholars and regulatory bodies in Malaysia. This entails not merely seeking post hoc approval, but actively involving them in the product development lifecycle to ensure that the underlying structure, terms, and operations of the financial product are unequivocally compliant with established Sharia principles as interpreted by Malaysian authorities. This method is correct because it prioritizes regulatory adherence and ethical integrity from the outset, minimizing the risk of non-compliance and reputational damage. Malaysian financial regulators, such as Bank Negara Malaysia, have established frameworks and guidelines for Islamic finance, and consulting with their appointed Sharia advisory councils, or equivalent bodies, ensures alignment with the specific regulatory expectations and the prevailing interpretations of Islamic law within the country, an approach that relies solely on internal legal counsel's interpretation of Sharia principles, without independent validation from recognized Sharia scholars or regulatory bodies, is professionally unacceptable. This fails to acknowledge the specialized nature of Islamic jurisprudence and the potential for differing interpretations. It also bypasses the established regulatory oversight mechanisms designed to ensure the integrity of Islamic financial products in Malaysia, creating a significant risk of noncompliance with Sharia law and civil regulations governing Islamic finance. Another professionally unacceptable approach is to adopt Sharia compliance frameworks from other ASEAN countries or jurisdictions without thorough review and adaptation to Malaysian specificities. There may be commonalities in Islamic finance principles. Each jurisdiction, including Malaysia, has its unique regulatory landscape and interpretations of Sharia. Implementing a foreign framework without local validation risks overlooking critical Malaysian regulatory requirements and specific Sharia interpretations endorsed by Malaysian authorities, leading to potential noncompliance. Finally, a strategy of seeking Sharia certification only after the product has been fully developed and launched, and then only if a customer complaint arises, is also professionally flawed. This reactive approach is ethically questionable and regulatorily unsound. It demonstrates a lack of commitment to proactive compliance and ethical product design. It also exposes the firm to significant regulatory penalties, reputational damage, and the potential need for costly product redesign or withdrawal if noncompliance is discovered. A professional decision-making process for similar situations should involve a commitment to understanding the specific regulatory environment of the jurisdiction, Malaysia in this case, identifying all applicable legal and ethical frameworks, civil law and Sharia law, and engaging with relevant experts and regulatory bodies early and continuously throughout the product development and implementation phases. Prioritizing transparency, seeking independent validation, and adopting a proactive compliance stance are crucial for navigating complex regulatory landscapes and maintaining professional integrity. Question 9. Operational review demonstrates that a multinational corporation is seeking to implement a new regional compliance framework across all ASEAN member states. Given the diverse legal systems and regulatory bodies present in countries such as Singapore, Malaysia, Indonesia, and the Philippines, what is the most prudent approach to ensure full legal and regulatory adherence in each specific jurisdiction? Option A. Engage local legal counsel in each ASEAN member state to conduct a thorough review of the proposed framework against their respective national laws, regulations, and judicial precedents, and adapt the implementation plan accordingly. Option B. Assume that a single, harmonized interpretation and implementation of the regional framework based on general ASEAN principles will be acceptable across all member states. Option C. Defer detailed implementation until specific enforcement actions or legal challenges arise in individual member states, then address compliance on a reactive basis. Option D. Rely exclusively on the legal interpretations and guidance provided by the originating entity or a central ASEAN coordinating body without independent country-specific verification. The correct answer is A. Engage local legal counsel in each ASEAN member state to conduct a thorough review of the proposed framework against their respective national laws, regulations, and judicial precedents, and adapt the implementation plan accordingly. Explanation. The scenario presents a professional challenge due to the inherent complexities of navigating diverse legal systems within ASEAN member states, particularly concerning the implementation of a new regional compliance framework. The requirement for strict adherence to the specific laws and regulatory bodies of each ASEAN nation, rather than applying a generalized or externally imposed standard, necessitates meticulous due diligence and localized expertise. This is professionally challenging because it demands a nuanced understanding of each country's unique legal traditions, enforcement mechanisms, and administrative procedures, which can vary significantly. The best approach involves a comprehensive, country-by-country legal assessment and adaptation strategy. This entails engaging local legal counsel in each ASEAN member state to thoroughly review the proposed regional compliance framework against their respective national laws, regulations, and judicial precedents. This ensures that the implementation plan is not only legally sound within each jurisdiction, but also practically feasible and culturally appropriate. This approach is correct because it directly addresses the core requirement of adhering to the specific regulatory framework of each ASEAN member state, as mandated by the principles of national sovereignty and the distinct legal structures within the region. It prioritizes accuracy and compliance by leveraging specialized local knowledge, thereby mitigating the risk of non-compliance and potential legal repercussions. An incorrect approach would be to assume that a single, harmonized interpretation or implementation of the regional framework across all ASEAN member states is sufficient. This fails to acknowledge the significant legal divergences that exist. Such an approach risks violating specific national laws, leading to penalties, reputational damage, and operational disruptions. Another incorrect approach would be to rely solely on the legal interpretations provided by the originating entity or a single, overarching ASEAN body, without independent verification by local experts in each member state. While such interpretations may offer guidance, they cannot substitute for the detailed, jurisdiction-specific analysis required to ensure full compliance with the distinct legal landscapes of countries like Thailand, Vietnam, or the Philippines. This oversight can lead to misinterpretations of local statutes and regulations, resulting in non-compliance. Finally, adopting a wait-and-see attitude, where implementation is deferred until specific enforcement actions are taken by individual member states, is professionally unsound. This reactive strategy ignores the proactive duty of compliance and significantly increases the risk of penalties and legal challenges. It demonstrates a lack of commitment to regulatory adherence and a failure to anticipate and manage legal risks effectively. Professionals should adopt a decision-making framework that prioritizes proactive, jurisdiction-specific legal analysis. This involves 1. Identifying the specific regulatory requirements of each ASEAN member state relevant to the compliance framework. 2. Engaging qualified local legal counsel in each jurisdiction for detailed review and advice. 3. Developing tailored implementation plans for each country based on local legal counsel's recommendations. 4. Establishing robust internal monitoring and reporting mechanisms to ensure ongoing compliance with country-specific regulations. 5. Fostering a culture of continuous learning and adaptation to evolving legal and regulatory landscapes within the ASEAN region. Question 10. Market research demonstrates a growing demand for proprietary software developed in Singapore, leading to potential licensing opportunities with a company based in Malaysia and another in Thailand. The Singaporean software developer anticipates gross royalty payments of SGD 500,000 annually from the Malaysian licensee and SGD 750,000 annually from the Thai licensee. Singapore has a double taxation agreement, DTA, with Malaysia that stipulates a 10% withholding tax on royalties, and a DTA with Thailand that stipulates an 8% withholding tax on royalties. Assuming these are the only applicable tax considerations under the ASEAN Framework Agreement on Intellectual Property, FPIP, and national laws, what is the projected annual net royalty income for the Singaporean developer from these two licensing agreements? Option A, SGD 1,175,000. Option B, SGD 1,200,000. Option C, SGD 1,125,000. Option D, SGD 1,250,000. The correct answer is C, SGD 1,125,000. Explanation: this scenario is professionally challenging because it requires a precise understanding of the ASEAN Framework Agreement on Intellectual Property, FPIP, and its implications for cross-border licensing within the specified member states, specifically focusing on the economic impact of royalty payments. The core difficulty lies in accurately calculating the projected royalty income under different tax regimes, necessitating a robust grasp of both intellectual property law and international tax principles as they apply within the ASEAN context. Careful judgment is required to ensure compliance with the FPIP objectives of promoting economic cooperation and the free flow of intellectual property, while also respecting the sovereign tax laws of individual member states. The best professional approach involves a detailed calculation of projected royalty income, taking into account the withholding tax rates stipulated by the double taxation agreements, DTA, between the relevant ASEAN member states and the licensee's country of residence. This method is correct because it directly addresses the economic realities of the licensing agreement by accounting for the actual net income received by the licensor after the deduction of applicable taxes. The FPIP aims to facilitate IP trade and economic integration, and accurately projecting net income is crucial for assessing the true economic benefit and for making informed investment decisions. This approach aligns with the spirit of the FPIP by providing a realistic financial picture that supports efficient cross-border IP transactions. An incorrect approach would be to simply sum the gross royalty payments without considering any withholding taxes. This fails to acknowledge the tax obligations that will reduce the actual revenue received by the licensor. Ethically and legally, it misrepresents the financial outcome of the licensing agreement and could lead to misinformed business decisions, potentially violating principles of transparency and accurate financial reporting within the context of cross-border economic activity. Another incorrect approach would be to apply a uniform withholding tax rate across all ASEAN member states without verifying the existence and terms of specific DTAs. This ignores the principle of national sovereignty in taxation and the specific bilateral agreements that govern tax treatment between countries. The FPIP does not mandate a single, unified withholding tax rate for all IP licensing within the region. Rather, it encourages cooperation and harmonization, but individual tax laws and DTAs remain paramount. A third incorrect approach would be to focus solely on the legal enforceability of the IP rights without considering the tax implications. While IP enforceability is a prerequisite for licensing, it does not negate the financial obligations associated with royalty payments. Ignoring tax considerations renders the economic analysis incomplete and professionally deficient, as it fails to provide a comprehensive view of the licensing agreement's financial viability. Professionals should adopt a decision-making process that begins with a thorough understanding of the specific IP rights being licensed and the relevant ASEAN member states involved. This should be followed by an in-depth review of the FPIP and any related protocols. Crucially, professionals must then research and apply the specific withholding tax rates stipulated by the applicable DTAs between the licensors and licensees' countries of residence. This systematic approach ensures that all relevant legal and financial factors are considered, leading to accurate projections and compliant business practices within the ASEAN economic framework. Question 11. The audit findings indicate that a financial institution operating in Alabama has not adequately demonstrated how its investment portfolio within ASEAN member states aligns with the principles and objectives of the ASEAN Framework on Climate Change. Which of the following actions best addresses this concern? Option A. Defer action on the audit findings, arguing that the ASEAN Framework on Climate Change is a non-binding regional agreement and does not impose direct regulatory obligations on the institution. Option B. Proactively review and update the institution's investment policy to explicitly incorporate the specific climate mitigation and adaptation goals outlined in the ASEAN Framework on Climate Change, and implement enhanced due diligence processes for all investments in ASEAN member states to assess their contribution to these goals. Option C. Rely on the institution's existing general ESG investment guidelines, assuming they sufficiently cover climate-related aspects relevant to ASEAN member states. Option D. Conduct a superficial review of the ASEAN Framework on Climate Change to identify broadly applicable climate themes and adjust marketing materials to highlight the institution's general commitment to environmental sustainability. The correct answer is B. Proactively review and update the institution's investment policy to explicitly incorporate the specific climate mitigation and adaptation goals outlined in the ASEAN Framework on Climate Change, and implement enhanced due diligence processes for all investments in ASEAN member states to assess their contribution to these goals. Explanation. The audit findings indicate a potential disconnect between a financial institution's stated commitment to environmental, social, and governance-esque principles and its actual investment practices concerning projects within ASEAN member states. This scenario is professionally challenging because it requires navigating the complexities of international frameworks, corporate responsibility, and the evolving landscape of climate finance, all while ensuring compliance with specific regional guidelines. The pressure to balance financial returns with ethical considerations, particularly in a sensitive area like climate change, demands careful judgment. The best approach involves proactively engaging with the ASEAN framework on climate change and its associated guidelines to ensure investment decisions align with its objectives. This means conducting thorough due diligence on potential investments to assess their contribution to climate mitigation and adaptation efforts as outlined by the framework. It requires understanding the specific commitments and reporting mechanisms established by ASEAN for climate action, and integrating these into the institution's investment policy and risk assessment processes. This approach is correct because it directly addresses the audit findings by demonstrating a commitment to responsible investment aligned with the specified regional framework. It upholds ethical obligations by prioritizing sustainable development and mitigating climate risks, which are central tenets of the ASEAN framework on climate change. An incorrect approach would be to rely solely on general ESG screening criteria without specific reference to the ASEAN framework on climate change. While general ESG principles are valuable, they may not capture the nuanced requirements and priorities of a specific regional framework like ASEAN. This could lead to investments that appear compliant on a broad level but fail to meet the specific climate action goals of the region, thus not fully addressing the audit findings. Another incorrect approach would be to dismiss the audit findings as a mere formality, assuming that existing investment strategies are sufficient. This overlooks the importance of adhering to specific regional commitments and the potential reputational and regulatory risks associated with non-compliance. It fails to acknowledge the evolving expectations for financial institutions to actively contribute to climate solutions as envisioned by frameworks like ASEAN. A further incorrect approach would be to implement superficial reporting measures that do not reflect genuine integration of the ASEAN framework on climate change into investment decision-making. This could involve creating reports that highlight climate-related activities without demonstrating how these activities are directly influenced by or contribute to the framework's objectives. Such an approach would be misleading and fail to address the core issue identified by the audit. Professionals should adopt a decision-making process that prioritizes understanding and integrating specific regional regulatory frameworks into their operational strategies. This involves a continuous cycle of research, policy development, due diligence, implementation, and monitoring, with a keen awareness of the unique requirements of each jurisdiction or regional bloc. When faced with audit findings related to international frameworks, the first step should be to thoroughly understand the framework's objectives and requirements, and then assess how current practices align or diverge, followed by a strategic plan to bridge any gaps. Question 12. Implementation of a new regional initiative to combat escalating air pollution across Southeast Asia requires member states of the Association of Southeast Asian Nations, ASEAN, to adopt a decision-making framework. Considering the diverse economic capacities and legal systems of the member states, which of the following frameworks would be most effective in ensuring tangible progress on reducing transboundary haze and improving air quality? Option A. A framework based on voluntary best practice guidelines and the regular exchange of scientific data and technical expertise among member states. Option B. A program focused solely on providing financial and technical assistance for capacity building in pollution monitoring and control technologies to member states, without establishing common environmental targets. Option C. A legally binding regional agreement establishing specific, measurable, and time-bound pollution reduction targets for each member state, supported by a dedicated dispute resolution mechanism for non-compliance. Option D. A system where each member state independently develops and implements its own national air quality standards, with ASEAN facilitating occasional high-level dialogues on shared concerns. Correct answer is C. A legally binding regional agreement establishing specific, measurable, and time-bound pollution reduction targets for each member state, supported by a dedicated dispute resolution mechanism for non-compliance. Explanation. The scenario presents a common challenge in regional environmental cooperation, balancing national sovereignty with collective action for shared environmental benefit. The professional challenge lies in navigating the diverse legal frameworks, economic interests, and political will of member states within the ASEAN framework to achieve a meaningful environmental outcome. Careful judgment is required to propose a solution that is both effective and politically feasible. The best approach involves establishing a binding regional framework that mandates specific, measurable, achievable, relevant, and time-bound, smart, Environmental targets for pollution reduction and resource management, coupled with a robust dispute resolution mechanism. This approach is correct because it directly addresses the limitations of voluntary agreements and provides a clear legal basis for accountability. The ASEAN Agreement on Transboundary Haze Pollution, while a step, often suffers from a lack of strong enforcement. A more effective framework would build upon such initiatives by incorporating legally binding commitments and a credible enforcement system, aligning with the principles of international environmental law that emphasize state responsibility for transboundary environmental harm. This fosters genuine regional cooperation by creating a shared obligation and a mechanism to address noncompliance, thereby promoting sustainable environmental practices across member states. An approach that relies solely on voluntary guidelines and information sharing, while valuable for building consensus, is insufficient for addressing urgent environmental issues like transboundary pollution. This fails to create legally binding obligations, leaving member states free to disregard recommendations without consequence, undermining the effectiveness of regional cooperation. Another inadequate approach would be to prioritize individual national economic development plans over collective environmental goals without any mechanism for reconciliation. This approach risks exacerbating environmental degradation and creating further transboundary issues, as short-term economic gains for one nation could impose significant environmental costs on others, violating the spirit of regional solidarity and shared responsibility inherent in ASEAN environmental cooperation objectives. Focusing exclusively on capacity-building initiatives without establishing clear, enforceable commitments also falls short. While capacity building is crucial for effective implementation, it does not address the fundamental need for agreed-upon standards and accountability mechanisms to drive meaningful change in regional environmental protection. The professional decision-making process for similar situations should involve 1. Identifying the core environmental challenge and its transboundary nature within the ASEAN context. 2. Assessing the existing legal and political landscape of ASEAN environmental cooperation. 3. Evaluating potential solutions based on their enforceability, feasibility, and alignment with international environmental principles. 4. Prioritizing approaches that establish clear commitments and accountability mechanisms, while also considering the importance of capacity building and information sharing as complementary measures. 5. Advocating for solutions that balance national interests with the collective good of regional environmental sustainability. Question 13. To address the challenge of expanding its manufacturing operations into Vietnam and protecting its proprietary technology, a company from Singapore, a member of the ASEAN Economic Community (ECA), must decide on its strategic approach. Given Vietnam's specific national laws on foreign investment and intellectual property, and the overarching goals of the AEC for economic integration, which of the following strategies best balances compliance and regional opportunity? Option A. Focus exclusively on complying with Vietnam's national laws and regulations, treating the AEC as a separate and largely irrelevant framework for operational decision-making. Option B. Interpret AEC objectives broadly to justify bypassing or modifying specific Vietnamese national laws that are perceived as hindrances to the company's expansion and IP protection strategy. Option C. Prioritize the general principles of AEC economic integration and free movement of goods and services, assuming these will supersede Vietnam's specific national regulations on foreign investment and intellectual property. Option D. Conduct thorough due diligence on Vietnam's specific foreign investment and intellectual property laws, while simultaneously identifying and utilizing relevant AEC agreements, mutual recognition arrangements, and dispute resolution mechanisms to facilitate operations and IP protection. The correct answer is D. Conduct thorough due diligence on Vietnam's specific foreign investment and intellectual property laws, while simultaneously identifying and utilizing relevant AEC agreements, mutual recognition arrangements, and dispute resolution mechanisms to facilitate operations and IP protection. Explanation. The scenario presents a common challenge for businesses operating within the ASEAN Economic Community, EC, navigating differing national regulations while striving for the economic integration envisioned by the AEC. The professional challenge lies in balancing the imperative to comply with specific national laws of an ASEAN member state, in this case, Vietnam, with the broader objectives and principles of the AEC. This requires careful judgment to avoid both legal noncompliance and missed opportunities for regional synergy. The best approach involves a thorough understanding of Vietnam's specific regulations concerning foreign investment and intellectual property protection, while simultaneously identifying areas where AEC commitments and frameworks can facilitate smoother operations or offer advantages. This means actively seeking out and leveraging existing AEC agreements, mutual recognition arrangements, or dispute resolution mechanisms where applicable, without compromising adherence to Vietnamese law. The justification for this approach is rooted in the dual obligation of any business operating within the AEC to respect the sovereignty and legal framework of the host nation, Vietnam, and to actively participate in and benefit from the integrated economic environment fostered by the AEC. This proactive and informed engagement ensures compliance and maximizes the strategic advantages of regional integration. An incorrect approach would be to solely focus on the overarching goals of the AEC without diligently investigating and adhering to Vietnam's specific legal requirements for foreign investment and intellectual property. This failure to prioritize national legal compliance can lead to significant penalties, legal disputes, and reputational damage within Vietnam, undermining any potential benefits derived from AEC initiatives. Another incorrect approach would be to ignore the AEC framework entirely and operate solely within the confines of Vietnamese law, treating the AEC as irrelevant. This overlooks the significant opportunities for streamlined trade, investment, and harmonized standards that the AEC aims to provide. Such an approach misses the strategic advantage of leveraging regional agreements and could lead to less competitive operations compared to businesses that actively engage with AEC provisions. Finally, an approach that prioritizes the AEC's goals to the extent of attempting to override or circumvent specific Vietnamese national laws would be fundamentally flawed. The AEC is designed to facilitate integration within the existing legal structures of member states, not to supersede them. Attempting to bypass national laws based on a broad interpretation of AEC objectives is a direct violation of national sovereignty and legal principles. Professionals should employ a decision-making framework that begins with a deep dive into the specific national legal and regulatory landscape of the host ASEAN country, Vietnam in this case. This is followed by an assessment of how AEC agreements, principles, and mechanisms can be leveraged to enhance operations within that legal framework. The process requires continuous monitoring of both national legal changes and developments within the AEC to ensure ongoing compliance and strategic advantage. Question 14. The review process indicates a dispute between Alabama and a neighboring ASEAN member state regarding the classification of imported agricultural goods, leading to differing interpretations of trade regulations. Alabama's trade representatives are considering several courses of action to resolve this issue. Which of the following represents the most appropriate and professionally sound approach for Alabama to pursue? Option A. Seek an immediate ruling from a domestic Alabama court to compel the other member state to adhere to Alabama's interpretation of the trade regulations. Option B. Initiate the formal dispute resolution process as outlined in the ASEAN Framework Agreement on Services and the ASEAN Protocol on Enhanced Dispute Settlement Mechanisms, starting with consultations. Option C. Launch a public diplomatic campaign, utilizing media outlets to highlight the perceived unfair trade practices and pressure the other member state into compliance. Option D. Unilaterally impose retaliatory tariffs on agricultural goods imported from the other member state until their classification practices are brought into alignment. The correct answer is B. Initiate the formal dispute resolution process as outlined in the ASEAN Framework Agreement on Services and the ASEAN Protocol on Enhanced Dispute Settlement Mechanisms, starting with consultations. Explanation. The review process indicates a complex dispute arising from differing interpretations of trade regulations between Alabama and a neighboring ASEAN member state, specifically concerning the classification of imported agricultural goods. This scenario is professionally challenging because it requires navigating the intricacies of international trade law within the ASEAN framework, balancing national interests with regional commitments, and potentially impacting economic relationships. Careful judgment is required to ensure adherence to established dispute resolution mechanisms and to avoid actions that could escalate the situation or undermine the principles of the ASEAN Economic Community. The best approach involves initiating the formal dispute resolution process, as outlined in the ASEAN Framework Agreement on Services and the ASEAN Protocol on Enhanced Dispute Settlement Mechanisms. This process typically begins with consultations between the member states involved. If consultations fail, the matter can be referred to a panel of experts for adjudication. This approach is correct because it directly aligns with the established legal and procedural framework designed to resolve inter-member state disputes within ASEAN. It prioritizes a structured, evidence-based, and impartial resolution, thereby upholding the integrity of ASEAN legal architecture and promoting predictability in regional trade. This method ensures that decisions are grounded in the agreed-upon rules and principles of ASEAN, minimizing the risk of arbitrary outcomes and fostering trust among member states. An incorrect approach would be to unilaterally impose retaliatory tariffs on goods from the other member state. This is professionally unacceptable because it bypasses the agreed-upon dispute resolution mechanisms, acting in contravention of ASEAN commitment to peaceful and structured conflict resolution. Such unilateral action risks escalating the dispute, damaging bilateral relations, and potentially violating ASEAN core principles of non-interference and consensus-based decision-making. It undermines the rule of law within the regional bloc and sets a dangerous precedent for future disputes. Another incorrect approach would be to seek an immediate ruling from a domestic Alabama court without first exhausting ASEAN internal dispute resolution channels. This is professionally unacceptable, as it attempts to resolve an inter-member state dispute through a national legal system, which lacks jurisdiction over disputes between sovereign ASEAN member states under the ASEAN framework. This action disregards the established regional legal order and the specific dispute settlement provisions agreed upon by all ASEAN members. A third incorrect approach would be to engage in public diplomatic pressure and media campaigns to force the other member states' compliance without initiating formal consultations. This is professionally unacceptable because it prioritizes public relations over established legal processes. While diplomacy is important, resorting to public pressure without following the prescribed dispute resolution steps can be seen as an attempt to coerce a settlement rather than achieve a resolution based on agreed-upon rules. It can also prejudice the impartiality of any future formal proceedings and damage the spirit of cooperation within ASEAN. Professionals facing similar situations should employ a decision-making framework that prioritizes understanding the specific dispute resolution mechanisms available within the relevant regional or international framework. This involves identifying the precise legal instruments governing the relationship between the parties, consulting with legal experts specializing in that framework, and meticulously following the prescribed procedural steps. The framework should emphasize a commitment to impartiality, evidence-based reasoning, and adherence to the agreed-upon rules, ensuring that actions taken are both legally sound and conducive to maintaining positive interstate relations. Question 15. A financial institution in Singapore is advising a client on a significant direct investment into a manufacturing facility in Malaysia, with a portion of the capital to be sourced from a subsidiary in Thailand. The investment aims to leverage the benefits of the ASEAN Economic Community (EC) blueprint. The client is seeking assurance that the investment structure will comply with the ASEAN legal framework concerning foreign direct investment and the free movement of capital. What is the most prudent course of action for the financial institution to ensure compliance? Option A. Conduct a detailed review of the specific ASEAN agreements relevant to foreign direct investment and capital movement, and then meticulously examine the national legislation of Singapore, Malaysia, and Thailand to determine how each member state has domesticated and implemented these agreements into their respective legal systems. Option B. Rely on the reputation and stated commitments of the Malaysian and Thai governments to facilitate foreign investment, without undertaking a granular legal analysis of their domestic regulations. Option C. Advise the client based on the general principles and objectives outlined in the ASEAN Economic Community Blueprint, assuming a uniform application of its provisions across all member states. Option D. Focus solely on the regulatory framework of Singapore, as the advising institution is based there, and assume that compliance with Singaporean law will inherently satisfy the requirements of the other ASEAN member states involved. The correct answer is A. Conduct a detailed review of the specific ASEAN agreements relevant to foreign direct investment and capital movement, and then meticulously examine the national legislation of Singapore, Malaysia, and Thailand to determine how each member state has domesticated and implemented these agreements into their respective legal systems. Explanation. Examination of the data shows a complex scenario involving cross-border investment and potential regulatory arbitrage within the ASEAN region, specifically concerning the application of the ASEAN legal framework. This situation is professionally challenging because it requires a nuanced understanding of how different member states' domestic laws interact with overarching ASEAN agreements, particularly when those agreements are not directly enforceable in domestic courts without specific legislative incorporation. The pressure to facilitate investment while adhering to diverse and potentially conflicting regulatory landscapes necessitates careful judgment. The correct approach involves a thorough analysis of the specific investment being considered, identifying which ASEAN agreements are relevant, and crucially, how each member state involved has domesticated or implemented those agreements into their national legal systems. This requires consulting the national legislation of each ASEAN member state to determine the precise legal standing and enforceability of the relevant ASEAN provisions. The justification for this approach lies in the principle of national sovereignty and the fact that international agreements, including those within ASEAN, typically derive their force within a member state from that state's own legislative action. Therefore, understanding the domestic implementation is paramount to ensuring compliance and providing accurate advice. An incorrect approach would be to assume that all ASEAN agreements are automatically and uniformly enforceable across all member states. This fails to acknowledge the principle of dualism, where international law and domestic law are separate legal systems, and international agreements only become binding domestically through specific legislative incorporation. Another incorrect approach would be to rely solely on the general principles or stated objectives of ASEAN economic cooperation without verifying their specific legal effect in the relevant jurisdictions. This overlooks the critical distinction between aspirational goals and legally binding obligations. Finally, an approach that prioritizes the perceived economic benefits of the investment over a rigorous legal compliance check would be ethically and professionally unsound, potentially exposing clients to significant legal risks and penalties. Professionals should employ a decision-making framework that begins with identifying the specific cross-border transaction and the ASEAN member states involved. This should be followed by a detailed review of the applicable ASEAN agreements and a comprehensive examination of the domestic legislation of each relevant member state to ascertain the extent to which these agreements have been incorporated and are legally enforceable. This due diligence process ensures that advice is grounded in the actual legal realities of each jurisdiction, mitigating risks and upholding professional integrity. Question 16. Upon reviewing trade data for a company operating under Alabama's purview, a compliance officer notices a pattern suggesting that imported goods from an ASEAN member state are consistently being declared with a lower value than their actual market price, potentially contravening the spirit and letter of the Alabama ASEAN Trade in Goods Agreement. What is the most appropriate course of action for the compliance officer to take? Option A. Contact the exporting company directly to demand an immediate explanation and threaten punitive measures if the undervaluation is confirmed, without involving any official bodies. Option B. Advise the company to continue with current trade practices while discreetly monitoring the situation, as a formal investigation might disrupt profitable business relationships. Option C. Immediately suspend all import activities from the suspected ASEAN member state until the issue is resolved, to prevent further potential violations. Option D. Initiate a detailed internal investigation to gather evidence of the alleged undervaluation. Consult the specific provisions of the Alabama ASEAN Trade in Goods Agreement related to customs valuation and dispute resolution, and seek guidance from Alabama's trade law experts or relevant state agencies before taking any further action. The correct answer is D. Initiate a detailed internal investigation to gather evidence of the alleged undervaluation. Consult the specific provisions of the Alabama ASEAN Trade in Goods Agreement related to customs valuation and dispute resolution, and seek guidance from Alabama's trade law experts or relevant state agencies before taking any further action. Explanation. This scenario presents a professional challenge because it requires navigating the complexities of international trade agreements. Specifically, the Alabama ASEAN Law exams focus on the trade in goods agreement, while adhering to the specific regulatory framework of Alabama. The core issue is determining the appropriate course of action when a potential trade violation is identified, balancing the need for compliance with the practicalities of international business. Careful judgment is required to ensure adherence to both the spirit and letter of the agreement, as well as Alabama's specific trade regulations. The correct approach involves a thorough, evidence-based investigation into the alleged violation, consulting relevant sections of the Alabama ASEAN Trade in Goods Agreement and any associated Alabama state trade regulations. This approach prioritizes understanding the facts, identifying the specific provisions of the agreement that may have been breached, and seeking clarification from the relevant authorities or legal counsel specializing in international trade law within Alabama. This is correct because it directly addresses the potential violation by gathering information and applying the specific legal framework governing trade between Alabama and ASEAN nations. It demonstrates a commitment to due diligence and compliance, which is ethically and regulatorily mandated. An incorrect approach would be to immediately cease all trade with the suspected violator without a proper investigation. This is professionally unacceptable because it presumes guilt without due process and could lead to unwarranted economic repercussions for both parties, potentially violating principles of fair trade and due diligence. It fails to uphold the investigative and procedural requirements often embedded within trade agreements. Another incorrect approach would be to ignore the potential violation due to the perceived administrative burden or the desire to maintain a smooth business relationship. This is professionally unacceptable, as it constitutes a failure to uphold regulatory obligations and ethical responsibilities. Ignoring potential violations undermines the integrity of the trade agreement and could expose the business to future penalties or legal challenges. It demonstrates a lack of commitment to compliance and good corporate citizenship. Finally, an incorrect approach would be to unilaterally impose sanctions or penalties on the suspected violator without consulting the agreement's dispute resolution mechanisms or relevant Alabama trade authorities. This is professionally unacceptable because it bypasses established procedures for addressing trade disputes, potentially leading to retaliatory actions and escalating the situation beyond a manageable scope. It demonstrates a disregard for the agreed-upon framework for resolving such issues. Professionals should employ a structured decision-making process that begins with identifying the potential issue, gathering all relevant facts and documentation, consulting the specific provisions of the Alabama ASEAN Trade in Goods Agreement and any applicable Alabama state laws, seeking expert advice if necessary, and then proceeding with a course of action that is consistent with the agreement's dispute resolution mechanisms and regulatory requirements. Question 17. When evaluating the potential impact of the Trade in Services Agreement, TISA, on Alabama's financial services sector, a firm is considering how to advise its clients on expanding their operations into the state. Which of the following approaches best aligns with ensuring compliance with both TISA commitments and Alabama's regulatory framework? Option A. Conduct a detailed comparative analysis of the specific TISA provisions related to financial services against Alabama's existing statutes, regulations, and licensing requirements to identify any necessary adaptations or potential conflicts. Option B. Rely on general interpretations of international trade agreements and seek advice only from international trade consultants, disregarding the need for Alabama-specific legal and regulatory expertise. Option C. Assume that TISA liberalization principles automatically grant foreign financial service providers the right to operate in Alabama, overriding any conflicting state-level regulations. Option D. Focus solely on the potential revenue growth from foreign investment, without a thorough review of Alabama's specific consumer protection laws and prudential regulations. The correct answer is A. Conduct a detailed comparative analysis of the specific TISA provisions related to financial services against Alabama's existing statutes, regulations, and licensing requirements to identify any necessary adaptations or potential conflicts. Explanation. This scenario is professionally challenging because it requires navigating the complexities of international trade agreements, specifically the Trade in Services Agreement, TISA, as it applies to Alabama's service sector, while also adhering to specific state-level regulations and ethical considerations. The core challenge lies in balancing the potential benefits of international service provision with the need to ensure compliance and protect local interests. Careful judgment is required to interpret the TISA provisions in the context of Alabama's economic landscape and legal framework. The best professional approach involves a thorough analysis of how the TISA commitments, particularly those concerning the liberalization of financial services, directly impact Alabama's existing regulatory environment for financial institutions. This includes scrutinizing provisions related to market access, national treatment, and regulatory transparency to determine if and how they necessitate changes to Alabama's current laws and practices. The justification for this approach lies in its proactive and compliant nature. By meticulously examining the TISA implications against Alabama's specific legal and regulatory framework, professionals can identify potential conflicts or areas requiring adaptation, thereby ensuring that any expansion of service provision aligns with both international obligations and state-specific governance. This aligns with the principles of good governance and responsible international engagement, ensuring that Alabama's participation in trade and services is both beneficial and legally sound. An incorrect approach would be to assume that TISA provisions automatically supersede all existing state regulations without a detailed comparative analysis. This failure to conduct a specific, jurisdiction-bound review risks noncompliance with Alabama's laws, potentially leading to legal challenges and reputational damage. Another incorrect approach is to prioritize the immediate economic gains from foreign service providers without adequately assessing the potential impact on local businesses and consumers, or without ensuring that these providers meet Alabama's established standards for consumer protection and financial stability. This overlooks the ethical obligation to ensure fair competition and safeguard the interests of the state's existing economic ecosystem. A further flawed approach would be to rely solely on general interpretations of international trade law without consulting Alabama-specific legal counsel or regulatory bodies, thereby ignoring the nuances of state jurisdiction and its unique regulatory requirements. Professionals should adopt a decision-making process that begins with a clear understanding of the specific TISA commitments relevant to the service sector in question. This should be followed by a detailed comparative analysis of these commitments against Alabama's current legal and regulatory framework. Consultation with legal experts specializing in both international trade law and Alabama state law is crucial. Furthermore, engaging with relevant state regulatory agencies and stakeholders, including local businesses, is essential to gauge potential impacts and ensure a balanced approach that fosters economic growth while upholding regulatory integrity and ethical standards. Question 18. The analysis reveals that an Alabama-based non-governmental organization dedicated to human rights advocacy is concerned about a specific human rights violation occurring in a member state of the Association of Southeast Asian Nations, ASEAN. The organization wishes to bring this matter to the attention of the ASEAN Intergovernmental Commission on Human Rights, ACER. Considering the ACER mandate and operational structure, what is the most appropriate and professional course of action for the Alabama NGO to pursue? Option A. Prepare a detailed, evidence-based report outlining the human rights concern and submit it through any established ACER channels for receiving information from civil society, framing it as relevant input for the ACER mandate. Option B. Focus solely on condemning the ASEAN member states' human rights record in communications with the ACER, without proposing any specific actions or areas for ACER consideration. Option C. Initiate a public social media campaign targeting individual ACER representatives, urging them to address the human rights violation without formal submission. Option D. Directly petition the ACER to launch an immediate, independent investigation into the human rights situation within the ASEAN member state and demand a binding resolution. The correct answer is A. Prepare a detailed, evidence-based report outlining the human rights concern and submit it through any established ACER channels for receiving information from civil society, framing it as relevant input for the ACER mandate. Explanation. The analysis reveals a scenario where a non-governmental organization, NGO, operating within Alabama, focused on promoting human rights, seeks to engage with the ASEAN Intergovernmental Commission on Human Rights, ACER, regarding a specific human rights concern within an ASEAN member state. The professional challenge lies in navigating the ACER mandate and operational framework, which is primarily designed for intergovernmental cooperation and engagement with ASEAN member states, rather than direct engagement with external NGOs on specific country-level grievances. The NGO must understand the acre limitations and preferred modes of interaction to effectively advocate for its cause. Careful judgment is required to ensure their approach aligns with the acre established procedures and maximizes the potential for their concerns to be heard and considered. The best approach involves the NGO meticulously researching the acre established procedures for receiving information and engaging with civil society. This includes identifying if the acre has specific channels for submitting reports or recommendations from non-state actors, or if engagement is typically facilitated through the relevant ASEAN member states' national human rights institution or government representatives. The NGO should then prepare a concise, evidence-based submission that clearly outlines the human rights concern, provides supporting documentation, and suggests potential areas for acre consideration or dialogue, framing it as information relevant to the acre mandate of promoting and protecting human rights within ASEAN. This approach is correct because it respects the acre intergovernmental nature and its established operational protocols, increasing the likelihood of a constructive response. It demonstrates an understanding of the acre role as a body that advises and makes recommendations to ASEAN member states, rather than a direct enforcement mechanism. An incorrect approach would be for the NGO to directly petition the acre for an immediate investigation or intervention into the human rights situation within the specific ASEAN member state, demanding the acre issue a binding ruling. This is professionally unacceptable because it misinterprets the acre mandate. The acre does not possess enforcement powers or the authority to conduct independent investigations in the manner of international judicial bodies. Its role is advisory and facilitative, working through consensus among ASEAN member states. Another incorrect approach would be for the NGO to bypass any formal acre channels and attempt to lobby individual acre representatives directly through informal social media campaigns or personal appeals without a structured submission. This is professionally unacceptable, as it lacks the necessary formality and evidence-based presentation expected by an intergovernmental commission. Such an approach risks being perceived as unprofessional and may not be taken seriously, failing to leverage the acre established mechanisms for receiving and processing information. A further incorrect approach would be for the NGO to focus its efforts solely on criticizing the human rights record of the specific ASEAN member state to the acre, without offering constructive suggestions or identifying how the acre mandate could be relevant to addressing the issue. This is professionally unacceptable because it is overly confrontational and does not align with the acre objective of promoting human rights through dialogue and cooperation. The acre is more likely to engage with information that is presented in a manner that facilitates its advisory and promotional functions. The professional reasoning process for such situations should involve a thorough understanding of the mandate and operational framework of the body one seeks to engage with. This includes identifying the body's primary functions, its limitations, and its preferred modes of interaction. Professionals should always prioritize formal, evidence-based communication channels and frame their requests in a manner that aligns with the organization's objectives and mandate. A proactive approach to research and understanding the institutional context is crucial for effective advocacy and engagement. Question 19. Comparative studies suggest that environmental regulations can significantly influence international trade and investment flows. For a company considering expanding its manufacturing operations into Alabama, which of the following approaches best addresses the potential impact of Alabama's environmental law on its trade and investment decisions? Option A. Implement standard environmental compliance measures that are common in other jurisdictions, without specifically investigating Alabama's unique environmental legal landscape or its implications for international trade. Option B. Conduct a comprehensive analysis of Alabama's specific environmental laws and regulations, assessing their potential impact on operational costs, supply chain management, and the overall attractiveness of Alabama for foreign investment, while also considering how these domestic regulations might interact with relevant international trade agreements. Option C. Assume that international trade agreements will override any stringent environmental regulations in Alabama, allowing for operations to proceed with minimal consideration for local environmental compliance. Option D. Prioritize securing trade agreements and investment incentives without conducting a detailed review of Alabama's environmental legal framework, believing that economic benefits will outweigh any potential environmental concerns. Correct answer is B. Conduct a comprehensive analysis of Alabama's specific environmental laws and regulations, assessing their potential impact on operational costs, supply chain management, and the overall attractiveness of Alabama for foreign investment, while also considering how these domestic regulations might interact with relevant international trade agreements. Explanation: this scenario presents a professional challenge because it requires navigating the complex interplay between environmental regulations in Alabama and the potential impact on international trade and investment. The challenge lies in balancing compliance with Alabama's specific environmental laws, which may have extraterritorial implications or influence investment decisions, with the broader principles of international trade and investment agreements that Alabama businesses engage with. Careful judgment is required to ensure that business strategies are both legally compliant within Alabama and strategically sound in the global marketplace. The best professional approach involves a proactive and integrated strategy. This entails conducting a thorough assessment of how Alabama's environmental laws, such as those pertaining to emission standards, waste disposal, and resource extraction, might affect the cost of production, supply chain logistics, and the attractiveness of Alabama as an investment destination for foreign entities. This assessment should also consider any potential conflicts or synergies with international trade agreements that the United States is a party to, and how these might influence investment flows. By understanding these dynamics, businesses and policymakers can develop strategies that mitigate environmental risks while fostering sustainable trade and investment. This approach aligns with the principles of responsible business conduct and the growing expectation for businesses to operate in an environmentally conscious manner, which can enhance long-term competitiveness and reputation. An incorrect approach would be to disregard Alabama's environmental regulations, assuming that international trade agreements supersede them. This is a significant regulatory failure because Alabama's environmental laws are binding within the state and directly impact operations. Ignoring them could lead to substantial fines, legal challenges, and reputational damage, undermining any potential trade or investment benefits. Furthermore, it demonstrates a lack of understanding of how domestic environmental policy can shape international economic engagement. Another incorrect approach would be to focus solely on the immediate economic benefits of trade and investment without considering the environmental implications. This approach fails to acknowledge the increasing global emphasis on environmental sustainability and the potential for environmental noncompliance to create trade barriers or deter responsible investors. It also overlooks the long-term risks associated with environmental degradation, which can ultimately harm economic stability and investment prospects. A third incorrect approach would be to implement environmental compliance measures in isolation, without considering their impact on trade and investment strategies. While compliance is essential, a fragmented approach misses the opportunity to leverage environmental performance as a competitive advantage in international markets or to attract environmentally conscious investors. This leads to missed strategic opportunities and potentially inefficient resource allocation. The professional decision-making process for similar situations should involve a holistic risk assessment and strategic planning framework. This framework should begin with a comprehensive understanding of the relevant domestic environmental laws and regulations. Subsequently, it should analyze how these laws interact with international trade and investment frameworks, considering potential impacts on market access, investment incentives, and supply chain management. Finally, it should involve developing proactive strategies that integrate environmental stewardship with economic objectives, fostering both compliance and competitive advantage in the global arena. Question 20. The investigation demonstrates that a financial institution in Alabama is experiencing a significant increase in cross-border transactions with businesses located in a neighboring state. To assess the AML risk associated with these transactions, the institution's compliance department has proposed several approaches. Considering the potential for regional variations in legal interpretation and enforcement of AML laws, which of the following approaches would best mitigate regulatory and financial risks? Option A. Apply a standardized, generic AML control framework to all cross-border transactions, irrespective of the counterparty jurisdiction or specific transaction characteristics. Option B. Rely solely on the stated AML laws and regulations of the neighboring state, assuming they are equivalent in practical application to those in Alabama. Option C. Develop and implement a quantitative AML risk scoring model that assigns risk points based on transaction volume, value, instrument type, geographic origin/destination, and available intelligence on the counterparty jurisdiction's regulatory enforcement climate, using a weighted average formula to calculate an overall risk score. Option D. Assume that federal and Alabama state AML laws are interpreted and enforced identically in all contexts, and therefore no specific assessment of regional variations is necessary. The correct answer is C. Develop and implement a quantitative AML risk scoring model that assigns risk points based on transaction volume, value, instrument type, geographic origin/destination, and available intelligence on the counterparty jurisdiction's regulatory enforcement climate, using a weighted average formula to calculate an overall risk score. Explanation. The investigation demonstrates a scenario where a financial institution operating in Alabama must navigate potential regional variations in legal interpretations and enforcement practices concerning anti-money laundering AML regulations, specifically in relation to cross-border transactions with entities in a neighboring state that may have differing regulatory oversight or enforcement priorities. This is professionally challenging because while federal AML laws apply uniformly, the practical application and scrutiny by state-level regulators or law enforcement can exhibit subtle differences, requiring a nuanced risk assessment that goes beyond mere compliance with the letter of the law. Careful judgment is required to ensure robust AML controls are maintained without imposing undue operational burdens. The best approach involves a proactive and data-driven risk assessment that quantifies the potential for illicit financial activity based on transaction patterns, customer profiles, and the known regulatory environment of the counterparty jurisdiction. This approach requires the institution to develop and apply a quantitative AML risk scoring model. For instance, a model could assign risk points based on factors such as the volume and value of transactions, the type of financial instruments used, the geographic origin and destination of funds, and any available intelligence on the regulatory enforcement climate in the neighboring jurisdiction. A simplified calculation might involve a weighted average of these risk factors, where the weights are determined by historical data and expert judgment. The formula could be represented as risk score equals sum I equals 1 NWI times FI where WI is the weight assigned to the ITH risk factor, FI is the value or score of the ITH risk factor, N is the total number of risk factors considered. This approach is correct because it directly addresses the potential for regional variations by embedding a quantitative assessment of risk into the decision-making process. It aligns with the spirit of AML regulations, which mandate risk-based approaches, and provides a defensible methodology for allocating compliance resources and implementing enhanced due diligence measures where necessary. This quantitative framework allows for consistent application across different scenarios and provides a clear audit trail. An incorrect approach would be to rely solely on the stated regulatory framework of the neighboring jurisdiction without independently assessing the practical enforcement realities or potential for differing interpretations. This fails to acknowledge that while laws may be written similarly, their application can vary, leading to a false sense of security. Ethically and regulatorily, this demonstrates a lack of due diligence in understanding the true risk landscape. Another incorrect approach would be to apply a uniform, one-size-fits-all AML control system to all cross-border transactions, regardless of the counterparty jurisdiction or transaction characteristics. This is inefficient and may not adequately address the specific risks posed by transactions with entities in regions with potentially weaker AML oversight or higher illicit finance prevalence. It fails the risk-based approach mandate and can lead to unnecessary operational costs. A third incorrect approach would be to ignore any potential regional variations and assume that federal and Alabama state AML laws are applied identically in all contexts. This demonstrates a failure to appreciate the complexities of interjurisdictional financial flows and the potential for subtle but significant differences in regulatory enforcement and judicial interpretation. This can lead to blind spots in the institution's AML program. The professional decision-making process for similar situations should involve a continuous cycle of risk identification, assessment, mitigation, and monitoring. Professionals should first identify all relevant jurisdictions and their respective legal and regulatory frameworks. This should be followed by a thorough risk assessment that considers both the formal legal requirements and the practical realities of enforcement and interpretation. Mitigation strategies should be tailored to the identified risks, and ongoing monitoring is crucial to detect emerging threats and adapt controls accordingly. A quantitative approach, as described, provides a structured and objective method for this assessment.